Welcome to the People's Law School. This is being brought to you by the McCracken County Bar Association and Paducah Channel 2. Today we are going to be talking about Social Security disability and the related programs. With me today is my colleague Denny Fentress. Dennis is a lawyer practicing here in Paducah. He graduated from the University of Louisville Law School in 1983, has been practicing since. For the last 18 years, his practice has been exclusively that of Social Security. I'm Craig Housman. I graduated from Vanderbilt Law School in 1973. I've been practicing in Paducah ever since the day after my last final. And my practice involves workers' compensation, Social Security, and accident cases. I guess a good place to start is, Dennis, if you would tell anyone who is thinking about applying for Social Security disability benefits what they need to do to find out, whether or not and when to apply.
Well, I guess the issue is whether you're able to work or not. So if you don't feel you're able to work and you're going to have a condition that will keep you from working for at least 12 months, then you may want to consider filing for your disability.
Is it possible for the person to keep on working until they find out whether or not Social Security will approve them?
It is possible, but that's kind of a tough situation. Social Security defines work as making more than $925 per month. So it is possible that you could actually work some and still be disabled. There's also a lot of other factors that come into play, like special accommodations if you're working like in a sheltered workshop setting, or maybe working for a family or friend that basically you're at the job but you're not really working. Or what you're working is not the what you're making is not really the actual worth of what you're bringing home, I guess. So it's possible, but generally it's difficult as far as working to be disabled.
It's been my experience that if the person wants to continue doing their regular work and that regular work generates more than $925 a month, and that's a month, and that's 4 1/3 paychecks because there's 4 1/3 weeks in every month. If they're still working and they're making more than $925, it's really premature to apply for Social Security, because they will not give you an advisory opinion on whether or not, when you stop working, whether or not they will pay you. It's sort of a leap of faith, and I don't know what the rationale is for that, but I know the very first question in Social Security's analysis on whether or not someone is disabled is whether or not they are working. Are they engaged in substantial gainful activity? So it's sort of my experience that if you're still doing your regular work, if you're working 30 or more hours a week and you're generating $925 a month, you just got a decision to make on whether or not to continue doing that or apply for Social Security. You cannot realistically do both. I mean, have you had the experience with somebody who's clearly disabled, terminally ill, know they're dying, and want to apply for disability benefits, but they don't want to give up their job?
All the time. And it's tough to tell them, that you've got to quit basically to apply. And it makes it a tough situation. Do you ever run into people that maybe apply and then try to go back to work and then maybe can't work?
Frankly, I get that question at least weekly, and my standard answer, and I think in the overwhelming majority of instances it's the right answer, is if you've got an opportunity to go back to work, if you've had some improvement in your condition, if you want to go back and give it a try, give it a try. It's a no-lose proposition. If the person is able to get back into the workforce and they're successful in doing that, then they're better off than receiving Social Security disability benefits. So they win that way. If they try to go back into the workforce and they find, because of their physical limitations, that despite their good intentions and trying to get back to work, they're just not able to do it, that is the best possible evidence. It really seems to be persuasive with nearly all of the judges that this is a well-motivated person, the kind of person that they want to give the benefit of the doubt to if it's a closed case. So I don't see any downside to the person trying to go back to work. They do need to realize that if they're successful in going back to work, they're not going to be able to draw Social Security disability benefits long term. But a trial work attempt up to even 3 months is not going to interfere with their ultimate, the decision of whether or not ultimately they are found to be disabled or not disabled. If somebody's going to this, they've made their mind up, I'm going to go apply, what do they need to do? Do they need to hire a lawyer right out of the box?
I don't really recommend that. You don't really need a lawyer until at least you're denied. There's no reason to retain one until Social Security determines that you're not disabled. I guess if you're determined or you made a decision to apply, you need to get your birth certificate and a list of all your doctors and addresses at the doctors you've seen, and contact Social Security, and they'll tell you exactly what they need. Things like your work history for the last 15 years would be an important thing to pick up. And the claims reps, at least locally, we got a pretty good group, and they really would tell you what they need.
I have this pet theory that the closer you get to the Potomac, the crazier Social Security seems to become. And so I prefer to deal with the folks at the local Social Security District Office and the local Office of Hearings and Appeals, and I think I've got lots of theories on why that is, but I've always found them to be more responsive, more reasonable. And just for anyone who's watching that may be thinking of applying, you won't find Social Security listed in the phone book in the black and white pages, but the Paducah District Office, the local Social Security number is 554-7776, and they're located at 125 Brett Chase in Lonoke. The Mayfield District Office phone number is 247-8095, and they're located at 318 South 7th Street. What about calling that 800 number that Social Security is really seems to encourage people to do? Is there a downside to doing that?
Well, as you pointed out, it's not a local person. You could be talking to somebody in the Dakotas or wherever. Also, the information you get from the 1-800 number may not be as consistent as it needs to be. They've done some studies and shown that even their own internal studies show that the information they give is not always the correct information. I don't know what percentages you may know, but it was.
The figure I saw was over 30% wrong answers with the 800 number. And
so,
what are your chances of speaking with the same human being twice if you dial the 800 number?
I would say not very good. I think that makes a big difference.
Yeah. Let's see. You mentioned that the district office personnel will suggest what people need to bring, and they can set up an appointment for doing this. One of the things that I don't know that they suggest is to sit down and make up a list of where the worker has been employed for the previous 15 years. It's my experience that 15 years, and actually I think it's a regulation, 15 years is the time frame that Social Security considers relevant. And for some technical reasons, it's really important to answer their questions truthfully, but there's no point. In fact, it is against the claimant's best interest to include more work history than that 15 years. So if you will do your homework before you go out and apply, and sit down at the kitchen table and maybe go through your income tax returns and look at your W-2 forms and can get a listing of exactly where you worked, when, in the 15 years before you became disabled, that helps.
I think it's a big benefit. Down the road, when you get to the hearing level, I think that's going to be important. But I guess I'm jumping ahead. Generally, what's the procedural process, if you don't mind telling everybody what goes on if you're denied?
Well, if you fill out the application at the local district office, and basically they want to know where you've worked, where you've received medical treatment. They ask you about what all's wrong with you, and they ask you some about your educational background. But then the actual decision gets made at that first step by a group of physicians that work with an agency of the Commonwealth of Kentucky in Frankfort or Louisville. I believe it's the Kentucky Department for Disability Determinations.
Division, maybe.
Division for Disability Determinations. At any rate, but those physicians never lay eyes on the claimant, much less examine them. They never speak with the claimant, much less examine them. They never see the patient's x-rays. They look at other doctors' reports, and they have to do quite a few of those. And then they fill out an elaborate form indicating what they think that claimant can still do. How many minutes he can sit at a time, how many hours in a day he can be on his feet, how much of the time he can stoop, bend, squat, whether or not he's got any problem handling, fingering, reaching, you name it. It's truly an elaborate form that they fill out, and where they get the input from that is sometimes a mystery to me. But at any rate, once the physician who's never seen the claimant fills out the form, then that more or less decides that person's the outcome at the initial level. Once they get turned, then the person gets a denial letter in the mail, and that frankly is a good time at which to think about hiring some help, because you're going to have a fight with Social Security over whether or not you're disabled if they turn you down at the first step. They do pay the most obvious cases, people who've just been diagnosed with terminal cancer or just had a massive stroke or are paralyzed or something like that. So they're about 30% of the folks get paid at the initial step, which is why they, you might as well see if you fall into the clear and easy favorable decision category before you hire a lawyer. But if you get turned down at the first step, it's been my experience that it is rare to be successful at the second step. How has that been in your experience?
About the same. I think the latest statistics I saw runs about 6% at the second level. And one thing I guess we need to tell too is you've got 60 days in which to file the appeal at the second step. So if you're going to retain an attorney, you need to get started at that point, because if you don't file within the 60-day period, unless you can show really good cause why you didn't file within that time period, you've got to start it all over again. And the initial decision, probably about 3 to 6 months has been my experience on average. And so that's a half year that you've lost if you don't file the appeal within the time period.
And that 60 days is a recurring time limit, I think, at all 4 levels of decision making by the Social Security Administration. Not only the first, but the second, the third, and the fourth. The appeal period is 60 days from their latest denial. So that's a good thing to remember. If they're going to hire a lawyer, are there some disadvantages to waiting to the 59th day to call?
Well, obviously, can you get in to see the lawyer? Usually somebody calls at our office, it's going to be difficult to get them in that day. So you're going to have to explain to them, you're going to have to file your own appeal, and then if you need our help after that, to give us a call. But you need to get started pretty soon after that.
And is it accurate that most, if not all, the lawyers I know work on the basis of a contingent fee, which is a contingent percentage of what the past due benefits are. So the more time passes before you get that appeal underway, the more of your money you wind up having to pay the lawyer for the same services. So it just is wise to go ahead and see somebody early if you're going to do that.
But again, you can pretty much expect to get turned down at the second level.
Yep.
The 6% pay rate kind of tells you that it's just not likely, and then you have to go to the third step, which is the hearing before the judge, and that's the.
How important is it to have legal representation when you are appearing at that third step, the hearing before the administrative law judge?
I think that's the one that's absolute necessary step to have a representative. You brought in the regulations, as you may want to demonstrate. This is the Social Security regulations.
Well, you got to know what's
so,
these pages.
So Craig has memorized that,
No.
but that's a step you need. That's the only opportunity that a claimant has to actually see the person who's going to decide if they're disabled. So it's their opportunity to tell the judge why they're not able to work. But of course, before you get to the judge, you need to have your records and information that demonstrate to the judge that you're not able to work, and that means getting your test results and, the important thing, your doctor's. The doctor's opinion saying that you're not able to do the things that you can't do, to demonstrate you can't do your past work or other work.
Okay. Is it accurate? I mean, we've talked about Social Security disability benefits. Is it accurate that the Social Security Administration has two different programs which pay benefits for Americans who are, well, Americans or residents here who are disabled?
Well, I guess there's actually four, but the main ones that we see is the Social Security disability and supplemental security income. Social Security disability Title II benefits are for the wage earners, for the people who've worked and paid in the Social Security program, and how much they draw is based on how much they paid in over the years that they worked. The other program, of course, is supplemental security income, SSI. You don't have to have ever worked to get that. You do have to be disabled. It's exactly the same standard. There's no more disabled or less disabled to get the SSI. But to get that, you also have to meet their financial requirements. You can't own a whole lot of stuff. You can't have income. As far as ownership, you can have a home. They don't count that. You can have a vehicle. They don't count that. Personal items. But if you've got anything else over $2,000, you're out. In the bank, another vehicle, a piece of property. We run that a lot. Somebody may have a piece of property they inherited or have a percentage they didn't realize that it's worth more than $2,000. And even if they're disabled, they're not eligible if SSI is the only thing that they're eligible for. And that means they didn't work and pay into the Social Security Disability Program. So we see that a lot. One question I get a lot, and you may too, is I'm always asked, can I draw SSI until my disability starts?
I do get that question, and it's the simple answer is no, and the reason is both for the supplemental security income benefits, which is just disability benefits for people who are disabled and poor, and Social Security disability, the program that's basically like a big socialized disability insurance policy. It's based on what you've paid in. But both systems use verbatim the same definition of disability, and it's not possible to be eligible medically and vocationally for one and not be eligible medically and vocationally for the other. Well, actually, it depends on, we get into the concept of insured status. Somebody could have insured status that expired at a point in time before. I had a case where we had the hearing yesterday where the fellow's insured status expired 6 years ago, and he was presently drawing supplemental security income benefits because he was now poor enough and he was disabled. But the question was, I mean, he would be eligible for disability benefits, but we have to prove he's been disabled since 2002 when he still had insured status all the way to the present.
Yeah. Insured status is kind of complicated, you know, in there. You have to basically work 5 out of the last 10-year period that your disability started. It's like a insurance policy. You know, you pay your premium, and as long as you pay your premium, you're eligible if something happens, you die or whatever. Same with disability. Once you stop paying into the disability program, then you've got a certain length of time to become disabled. So that happens a lot. Is there any advantage? I know I have a lot of clients, and I'm sure you do too, that are basically apply for both, and yet their disability, SSI, the maximum you can draw is $637 per month, but their disability is more. So when they start drawing a monthly check, they just draw disability, because for SSI it's a dollar for dollar reduction against any income. But is there any advantage to a claimant filing for both, even though their disability is going to be what they'll be drawing monthly?
There can be. And that's a very good thing for us to get across to anybody who's watching us. And let's take the circumstance where someone was just involved in a major motor vehicle accident and they're really badly banged up, or they've had some other devastating injury and they've got huge medical bills that are running right then. If they go ahead and apply for supplemental security income benefits, they need to do that right away if there's any reasonable possibility that they're going to be disabled for 12 continuous months. Because with the supplemental security income program, there's no retroactivity. The month after the month in which you apply is the first month that you can receive any benefits. If you are eligible for supplemental security income benefits, you get Medicaid for from the first month that you're eligible for any supplemental security income benefits. With Social Security disability, you become eligible for Medicare, but that's 2 years after you prove that you've been disabled, plus the 5-month waiting period. So it's 29 months after you had the car wreck or you got hurt at work or whatever, before you get any help with medical bills. And so if you have some sort of devastating accident or injury and you're going to have surgery and you've been in the hospital and you've got big bills and there's a chance that you're poor enough and that your disability is going to last 12 months, it is really important to pick up the phone and dial 247-8095 or 554-7776 to talk with the district office, and over the phone you can get your foot in the door, so to speak. You can reserve your spot, you can preserve that date as when you first made an inquiry about supplemental security income benefits. And if it does turn out that you are disabled for 12 continuous months, if for instance you had the wreck in October and you apply in October, then whatever medical bills you have beginning in November, you can get Medicaid to pay. And then there's also another advantage with Social Security, the regular Social Security, based on what you've paid in. I guess they think that everybody has 5 months worth of income saved up that they could live off of. That's not true in my experience, and it's personally not true of me. But at any rate, you don't get any Social Security disability benefits for the first 5 full months that you prove that you're disabled. Whereas with supplemental security income benefits, while there's no retroactivity, I mean, they won't go back before the month in which you applied, there is no waiting period. So if you apply, particularly in a situation where you've had major medical expense and you've had some big injury or something of that sort, it is important to apply for the supplemental security income benefits if you may be eligible, and do it right away. Let's see.
How about the hearing part? I get a lot of questions on that, like what's it like at a hearing?
It depends on which judge you draw.
You mean judges are different?
Yes, they're like any other large group of human beings. In the 35 years I've been doing this, we've had a few judges who would be on the Santa Claus end of the spectrum, and there seems to be a lot more on the Scrooge end of the spectrum, and most of these folks are somewhere in the middle. I won't say all, but most have been real reasonable, fair-minded folks who seem to be genuinely interested in rendering a fair decision based on the evidence and the law, as they saw it. It makes a huge difference if you have someone with you who knows what is supposed to be important to the judge and what isn't important to the judge. I mean, do you run across some really common misunderstandings in the people you deal with about what would be important to a judge?
Always. It seems like a lot of my clients would like to tell the judge that they know all these people or friends that they're disabled and they're have a lot more problems personally than they do, and that's not what the hearing is about. The hearing, again, is the claimant's opportunity to tell the judge the health problems that they have that keeps them from working. The hearings are pretty informal. They're not open to the public. You don't have people walking in and out. It's not like a Judge Judy or, I guess with our age, Judge Wapner situation. Nobody screams and hollers at people. It is recorded, and it is part of the record of what's said at the hearing. But for the most part, it's pretty laid back. It's a lot more laid back than TV courtroom type stuff. But the key is preparation, knowing what to say.
And what evidence to get into the record before the hearing.
That's
One of the
correct.
things that when I went to my first Social Security hearing 35 years ago, I wanted to tell the judge that nobody was going to hire my client. Is that a good argument to make? Makes a lot of common sense.
And it's hard to explain to people that that's not the issue for Social Security. It does not matter that nobody will hire you for the job, or you cannot go back to the job that you did. It doesn't matter that the job doesn't even exist in this area, or a job pays minimum wage. The issue for Social Security is not whether anybody will hire you, whether you can do a job, and that generally is any job, not just your past work. But of course, age comes into play. The older you are, the easier it gets to get your Social Security. It becomes easier, but that's a big issue that people.
Once someone is successful and is awarded Social Security disability benefits, does that mean that they will continue receiving those for the rest of their lives?
No. Social Security is required to periodically review people for medical improvement. Typically, it's about every 3 to 5 years, but it can be sooner than that. It depends on the nature of the disability. A person could have a severe orthopedic injury where they're going to be out for a year, but after a year they should be better and able to go back to work. So it may be reviewed after 12 months. And a lot of times if you have a hearing before a judge and you're awarded by the judge will note in the decision that the case should be reviewed within a 12-month period or 3 to 5 month period with medical treatment that their condition should improve.
Okay. Well, speaking of time periods, I think we have come to the end of our allotted program time for discussing Social Security, and we want to thank those who have been listening to us, and hope and thank Paducah too for allowing us this opportunity to share with the public some of our experiences in dealing with the Social Security disability system.